My wife knows how to work a red carpet. I'll say that. Yeah, she might be the Beyonce of red carpets. So she's turned that into an athletic event. I see what goes into that. Real science. It's unbelievable. You guys see the finished product. I see a totally destroyed closet, bedroom, and kitchen by the time she walks out the door. So yeah, you're like, I don't even know how shoes got in the freezer.
Hi, friends. It's Katie from Without a Crystal Ball. Welcome back to my channel. Have you heard the story about how Brian Friedman has challenged Blake Lively to a live stream deposition? And she's apparently avoiding her deposition. And he suggested that since she's willing to testify, we should just do it in Madison Square Garden, live stream it, donate all the proceeds to a nonprofit that helps people that are impacted by DV. And then he asked if she would be ready to sit for the deposition since she's been otherwise occupied and not responding. Interesting, right? Okay. Well, while she's avoiding her deposition and not wanting to coordinate that, Stephanie Jones is back in court and she's responding to counterclaims that have been brought against her. And I want to preface this video by saying one thing and one thing before we start. We are talking about a case that is supposed to be about women and believing women and not using degrading language and being cognizant and mindful of, like, not marginalizing women. And I'm finding a lot of the rhetoric written by female lawyers to be very misogynistic, specifically on the side of Stephanie Jones and on the side of Blake's attorneys. It feels like in their eyes, they can believe their clients, but if the other opposing parties are women, we don't believe them. And if the other opposing parties are women, it's okay to degrade their intelligence and their experiences and use derogatory and inflammatory language in motions as long as you believe women, even though we're attacking women. And that's really what I don't like about this, is that it's hypocritical. And when I was a kid, I remember a teacher in high school, I think it was my communications teacher, saying, "You're losing an argument when you have to resort to personal attacks on the other party. You should be able to win an argument without using inflammatory language, derogatory language, and without attacking the character of the individual. Don't go low. It's the sign of a losing party. It's the sign of a losing litigant when you start attacking the person rather than the legal claims." And I just find it odd that a woman, Kristen Taylor, who's a attorney based out of California and who is a high profile attorney, I just realized, and she is very well educated, would resort to such disgusting language. But that's where we're at. But we're going to talk about some of the issues I'm seeing with this motion to dismiss without necessarily going into all of it, because a lot of it is just inflammatory language that's being used, in my opinion, for the purpose of press releases through the court to smear and degrade their targets. And I see it happening on both sides. I mean, I want to be clear. Like, they use inflammatory language when they talk about Stephanie Jones. They use inflammatory language at times when they talk about Blake Lively. And I truly wish that both sides would stop that if we're supposed to be not going after women. You know what I mean? We should be like playing nice in the sandbox. Do we need to have like a timeout and talk about it and like hold hands, have some Kool-Aid, maybe get a little snack? Okay. So the one thing about motions to dismiss is that they are designed to be used as a legal procedure in federal court where a defendant argues that a plaintiff complaint fails to state a claim upon which relief can be granted. They're basically telling the court that the plaintiff's lawsuit, even if the allegations are true, doesn't have a legally valid basis for the claim. It's to dismiss it before it goes to trial. But the The problem here is that the court has to accept all of the allegations that the plaintiff makes as fact. So they have to be able to get around the fact that the court can't just decide based on the complaint allegations. They have to consider those as fact. A motion to dismiss is not a place to introduce evidence. It is not a place to argue your case. It's not a place to argue your position. It's simply a place to look at the merits of the claims made by the other party and why it fails to state a claim, which is the basis of all of this motion 12b6 that she put forth. She's not arguing that they have the improper venue. She's not arguing really any of that. It's all about failure to state a claim. And in order to meet the Rule 8 rules of civil procedure, in order to state a claim properly, the it the plaintiff is required to give a short and plain statement of the claims that will give the defendant fair notice of what the plaintiff's claim is and the ground upon which it rests. And the Supreme Court has held that while a complaint attacked by the Rules 12b6 motion to dismiss does not need detailed factual allegations, a plaintiff's obligation to provide the grounds of the entitlement of relief requires more than labels and conclusions, and a formulaic resuscitation of elements of the cause of action will not do. So, to survive a motion to dismiss, a complaint must contain sufficient factual matters accepted as true to state a claim to relief that it's plausible on its face. That is from legalresearch.com. Okay. So, what they are going to argue throughout this entire motion to dismiss is that she has not pled sufficient facts and she is simply reciting elements of the cause and giving legal conclusions. A benchmark of a solid motion to dismiss in federal court would be that you would not introduce evidence that's outside of the four corners of the complaint. So you would not insert text messages or screenshots basically of text messages into a motion to dismiss because the court will not consider evidence that has outside of the four corners of the complaint. And in this case, immediately they introduce all kinds of screenshots of text messages. And the problem here is that the court has no way to authenticate how these messages were obtained. They can't rely on what Stephanie says because it's not about what Stephanie says. It's about what Jen Abel says. And her complaint makes clear that those messages were obtained through a sham subpoena and were taken from her iCloud and from her personal email, not her work email. And they are going to rely on this idea that this is all about an employer can access anything on a company phone. And that's actually not true. That's not true. There have been plenty of court cases that have gone through the Court of Appeals that have published decisions that employers do not have a right to look at the personal information, like, or to access the Gmail accounts of somebody that worked for them, even if it's on their work phone. They don't have a right to access a personal Gmail account. They can access their company accounts. So she can pull all day she wants from Jen Abel's JonesWorks account, but she doesn't get to go into her personal email or her new work email just because it's linked to the phone and use it because she wants to. It's generally considered outside the bounds of authorization of an employer, a former employer, to access the personal Gmail, even if it's on their phone. And the reason why is because Gmail doesn't store the data on the phone. The data that's obtained from the Gmail account is stored on Google. And so if she's going into Google and she's taking out Jen Abel's emails from Gmail, that's not actually what's on the phone. Some of the text messages very well can be on the phone, right? They also can end up in the cloud, but they can be on the phone. Her work email would be on the phone because it's a server that Jones Works owns. But she does not own the iCloud, nor does she own the Gmail. And so those are not for her to access. And she would have to be able to prove that this unauthorized access of these accounts was lawful. From everything that I can glean, from everything that I've read, the better practice in all of this would have been that she not accessed it because there's liability here and that can go against her for doing this. And it would have also benefited Stephanie to have a policy about the data on these phones and a policy about what you can use your work computer for. But Jen Abel says they didn't have any sort of policies, and that's not going to help Stephanie. And Stephanie's attorneys somehow are claiming that Jen agrees that this was a lawful subpoena, even though that's not what Jen is arguing. What I realize about these motions to dismiss is that the first one they pled, they actually did a much better job because I think there were a lot of key problems in what they pled for California. And in this case, what they're doing is they're removing the California so that they don't have to argue about jurisdiction. And then they're going directly to federal laws so that there's no disagreement about if the federal court has jurisdiction over these claims. And that's kind of where they're falling apart because they don't have the best arguments for why these claims need to be dismissed. So I'm not a judge, I'm not a lawyer, right? But I'll just read you a little bit of like what their preliminary statements is just to give you an idea of how they started this. Jennifer Abel's counterclaims are a rotating game of a whack-a-mole where the minute one baseless theory is debunked, another even more implausible theory pops up in its place. In her amended counterclaims, Abel abandoned 6 of the misguided counterclaims she originally filed against Jones and Jones Works, including the fantastical story that she was falsely imprisoned by her former employer during a termination meeting. Instead, she now claims even more desperately that she was hacked by Jones Works acting as a spy. The new theory follows the familiar pattern and has an obvious purpose to draw attention away from the text messages that she cannot and does not deny she wrote, and that form the basis of Jones' well founded claims against her for which she has no viable defense. Those text messages conclusively corroborate that Abel brazenly conspired to steal Jones Works clients and documents and trash her employer on her way out the door. And then she puts in text messages that are not actually sent from Jen. They're sent from Melissa Nathan. So these are Melissa Nathan's words to Jen, not Jen saying any of this to Melissa Nathan. And what I find interesting here is that she's not addressing this towards Melissa. She's addressing this towards Abel as these are her words. And it's, I know once you are gone, we will be on accounts together and make really good money and be happy. And let's just keep it steering that way. And you take the effing client and never talk to her again. I swear to God. Those are not Jen Abel's words. They're set messages to Jen. And they're also not a part of her counterclaims. So they're outside the bounds. And there's really no basis for inserting those into this. This is all just, again, a way for her to use these messages to humiliate her. And it says they reveal that she made no effort to hide her malice against Jones Works or her plan to go to war with Jones Works, holding them hostage on her way out the door. And then she includes a text message from Jen Abel to Melissa Nathan with no context whatsoever. And it says, we are going to war. We have no idea what that even means. Going to war with who and for what? And another is holding them hostage from Jen Abel to Melissa Nathan. And that was in reference to Jen Abel giving Stephanie Jones a list of grievances on her way out the door of what she experienced and endured while she was at work. It's hyperbole. It's not actually serious. And then she says, and they uncover that unsatisfied with only stealing clients, she also set about to steal Jones Works' confidential documents, even boasting of her ability to evade the security measures the company took to stop her by using hundreds of different emails to infiltrate Jones Works. So Elisa Jessup is an attorney. She works in the state of California. She also is, I think, a professor at Pepperdine, and she's in the same area. And she certainly could have been hired by Jen as like a consultant for litigation. Okay. And Alicia, this text to her says, she said, I have my way around that shit because I have hundreds of different emails for each domain that I own so she can suck it. Now, for instance, here, that doesn't say anything about infiltrating Jones Works systems. That says that she has emails for domains that she owns. Domains that Jen Abel owns, websites. So she's not infiltrating Jones Works. She's talking about her own websites. And again, it's not even relevant because this is outside the bounds and they're not explaining why it's relevant in the motion to dismiss. And then they resort to insults. Her two-faced and scornful behavior was not just reserved for Jones Works. Despite publicly hitching wagon to Baldoni, behind his back, she was trashing him. And then she's pulling text messages from January of 2024, which again isn't relevant. It's just a way to character assassinate her. Like say, oh, well, Baldoni went with her. Well, look, she talks crap about you guys. And then she brings up Melissa Nathan. Even Melissa Nathan could not escape Abel's treachery. And she shares a couple text messages lacking context again to prove something that we don't know what it is. So if you're about to like set up the stage for your motion to dismiss, I would say the worst thing that you could do is resort to derogatory insults by calling her two-faced and scornful, and then using words like treachery and being derogatory about what a horrible woman this person is, right? And then introducing evidence that isn't even going to be considered by the judge. That to me feels like a motion to dismiss that doesn't have meat or teeth. And remove the fact that she got rid of other claims. She got rid of other claims because she found out about the subpoena. And once she found out about the subpoena, she could attach different legal claims to it. And she could, instead of arguing about the state of California, because that's what Stephanie wanted to dismiss, she converted the state claims to federal claims, which have more robust protections. They say that each and every one of her claims should be dismissed with prejudice. And to further drive home that she's lost the plot, that means Stephanie Jones and her attorneys are basically just putting this together because she's getting billed to do this. Instead of actually looking at the facts and the general allegations of the complaint, she twists words to try to insinuate that Jen Abel admits that the phone data was handed over with a lawful subpoena, which is actually not what she said, because in the new amended complaint, it says that on September 27, working hand in glove with Jones Works and the Lively parties and their counsel, they initiated a sham legal proceeding in New York State Court. The sham lawsuit was nothing more than a transparent ploy to obtain subpoena power. The plaintiff, Van Zandt Inc., is an inactive corporate entity affiliated with Lively and Reynolds and entirely unrelated to the film or to the Wayfair parties. The lawsuit asserts 3 causes of action: breach of contract, breach of implied covenant of good faith, and fair dealing and faithless servant against Doe defendants only. The lawsuit does not explain how or why Van Zandt was unable to identify proper defendants, especially in the context of a breach of contract action. And they implausibly claim not to be privy to the identities of its own contractual counterparties or its own employees, contractors, agents, or representative. It's devoid of specific allegations against anyone, much less Abel. It relies on boilerplate legal jargon. It never got a judge assigned. They never substituted Doe defendants. And that on the very same day that the lawsuit was filed, Jones warned a departing employee not to work for Abel because her business wouldn't be around much longer, meaning they have a witness that told them that. They have that in a witness. They're not going to put that in if they don't have a witness. And they say once the lawsuit was filed, which they're calling a sham, an abusive process, they issued a subpoena to Jones Works for all the data stored on her phone, including private communications from her iCloud and email accounts, as well as potentially privileged information. There was no identifiable parties and no party had to be served. The subpoenas were issued without notice, depriving Abel of any knowledge of the subpoena, much less the opportunity to object. So in all of that, Stephanie's lawyers say, oh, so they agree that it was a lawful subpoena. That's not what they said. They say that she admits that the phone itself would belong to Jones Work, that she returned it voluntarily, and that she provided them with the passcode to access it. That again is not what she said. She gave the passcode for the limited purpose of transferring the phone number. And they say that her own allegations prove that Jones Work didn't and couldn't have hacked anything. The very circumstances that Abel pleads doom her claims from the onset. Any hypothetical access using credential Abel voluntarily provided cannot, as a matter of fact, be unauthorized. So what they're saying to the court is, yeah, we actually did access that. We did, but she gave us the passcode, so we had authorization. But if they told her that it was for the limited purpose of transferring the phone number, I think they're gonna have a hard time overcoming that, and the judge has to take that as true. Not to mention, there's been courts that have specifically held that just because an employer has access to the phone and just because they left Gmail open or they left the iCloud open and accessible doesn't give the employer the right to scrape the data from those because it's Gmail and iCloud, and those are on a private server that are not owned by JonesWorks. So it doesn't belong to her and it's not hers to have. Just because it's there on that phone doesn't mean it's hers. She's arguing about New York not recognizing privacy based torts, that they did nothing wrong in retrieving the phone when it fired Abel, and that Abel has no property interest in the phone number, and JonesWorks somehow can't convert something that she didn't own. Something else I noticed outside of just how this is all constructed is that this is really about Stephanie putting a narrative out to counter what she said. I feel like this document is not for the judge. It feels like it's much more for the public. And you can do a basic search on what is appropriate and not appropriate in a motion to dismiss, but it's not appropriate to introduce new facts into a motion to dismiss or to introduce facts that are not a part of the complaint that you're contesting, because the judge doesn't dispute the facts of the case. He has to dispute the law. In her motion to dismiss, she's basically introducing a whole lot of new facts to counteract what Abel is claiming. But statements of facts are a question for the jury, not for the judge. So having a dispute about the facts, this is not an appropriate time for her to start talking about, I didn't do this, I didn't do that, she was stealing from me. She has to look at the basis of the actual complaint that Jen filed to decide, okay, what are the legal flaws, not the factual disagreements. Here's an example of her inserting information that is not relevant. In mid-August 2024, JonesWorks learned after inquiring into suspicious file transfers on its computer system that Abel had been downloading dozens of proprietary documents from the company's systems to her personal laptop, which she had no reason or authorization to access, let alone surreptitiously misappropriate. JonesWorks swiftly responded and on August 21st, 2024, with counsel, terminated Abel. This is a disagreement on facts. It's not a disagreement on law. And so it's just not relevant. What they're doing is filling pages with information that the judge isn't even going to consider. Rewriting the narrative, rewriting the story so that it fits them, but the judge doesn't care because none of this is relevant to her complaint. It would be easy for me to read all of what she's saying about Jen so that you can hear it, but really all it serves is to slander her and degrade her and demean her, to make her look like this evil, vindictive woman that is two-faced and scornful. It's a smear campaign via the factual allegations. And if they were serious about this motion to dismiss, they wouldn't be disputing facts. That's my opinion. Getting past this level and having a case dismissed, Jen will survive her claims. They won't, because they're not arguing law, they're arguing facts. And then their argument right off the bat, I think, is really poor because it says that the Computer Fraud and Abuse Act is designed to target hackers who disrupt or destroy computer functionality. And that's not true. It's not only designed to target hackers that are outside, but it's also target insiders that are within the same system that are going to use the information for in illegal or malicious ways. And they access parts of the phone and of the data that exceeds their authorization. And she says that it's only for people that are going to disrupt or destroy the computer functionality, which is just not true. And it's to prevent hackers from obtaining, altering, or destroying certain stored electronic communications. But that's, again, not true. Jen Abel is relying on this part of the law where it says that you can exceed authorization, meaning you had authorization for certain aspects, certain files, certain folders, certain data, but you didn't have authorization to go into other areas. And courts have held that employers going into people's personal emails is outside of the bounds of a authorized access Just giving your employer a passcode to get into the phone so they can transfer it isn't authorizing them to go into your Gmail account because the phone is on and the Gmail is linked. If you're going into the Gmail and taking the Gmail from the phone and you are accessing that Gmail, you have exceeded your authorization. That's Jen's argument. And that is, under this law, what would constitute hacking. It's not the same kind of hacking, it's a different kind of hacking. But they're relying on, like, thinking about, the anonymous people that are behind their computers and they're going into other people's websites and databases and stealing all of the data. That's not what is happening here. What they're saying is she went into my personal emails and stole all my data. I also found it pretty odd in the motion to dismiss that she relies on a lot of questions or like rhetorical questions that obviously can't be answered, where she talks about how she alleges conclusory, unsupported fashion that Jones Works bypassed the password protection on her accounts, and how, using what technological means, in what circumstances. She similarly alleges that Jones Works was monitoring and intercepting her private communications in real time. Again, how, when, what communications, and what is her basis for believing or alleging this? And she goes into the accessing protected computers. So she says, in a similar vein, Abel alleges that Jones Works accessed protected computers knowing and without authorization or consent, or in a manner that exceeded their authorization. This again is a conclusion of law and recitation of statutory element, not an alleged factual basis for her claim. And further, which is it? How did the company that owned the phone lack authorization to use it? Because the law says that you can access the phone data, but you can't access the other protected computers that are not owned by the phone. Your Gmail that's on your phone is not stored on your computer. Your iCloud is not stored on your computer. It's stored with Apple at a server, wherever the servers are, and then Google has servers in other places. And so even though it's accessible through the phone, it's not, and it's, you can see it on the phone, it's not stored on the phone. And that's the storage data issue, is she's getting data from a protected computer that's not hers to own. And she's just saying, well, I had access to it. So how am I, getting access to the stored information? How did they overcome generally applicable rules regarding access to the computers? What even were these rules? And how could Jones Works possibly overcome rules simply by using a passcode that Abel admits she provided to it? Well, if Abel had her iCloud email, so on Apple, I don't know if you're an Apple user, you can actually set up your email to have all kinds of different inboxes through your iCloud. So you can have your Gmail, your iCloud addresses, your work emails all through the same system, and you can set up the proxies so they all go to the same inbox. And so if her email was set up, her Gmail account was set up to the inbox on the computer, on the phone, those Gmail accounts are not Stephanie's. And if she's accessing the Gmail accounts, she's not accessing Jones Works files. She's accessing Jen's Gmail account on the Gmail server. So just having the app password doesn't excuse her from abusing that by looking at the Gmail account. And then she again goes that she's incoherent and that she suffered enormous harm to her personal and professional life and suffered damages and suffered harm and injury, and that it's not stating a plausible claim that they can conduct specified harm. I think the biggest challenge for Jen Abel is going to be the text messages, because if the text messages were left on the phone and they were downloaded on the phone, which they often are, those would be technically considered property of Stephanie Jones. I think the bigger issue is if she's going into her iCloud or if she's going into the Gmail and accessing the private emails. They referenced this case where someone left, an employee was terminated, but he left his cloud connected to his iPhone. And so text messages were still going into the phone. And they referenced this case because in the case, the court ruled that by leaving it open, the employer didn't intentionally intercept. So they didn't violate the wiretapping. And I don't know if that's the case, but if she was going into the Gmail, that could be a bit bigger problem, because there's another case that was ruled on in 2013, Lizette versus Kalmaketti, and it's between Verizon Wireless and an employee. And they alleged that Verizon accessed and read 48,000 of the employees' emails over 18-month periods. The emails contained communications about their family, career, financials, health, and other personal matters. The Verizon employee opened emails that the former employee had not even opened yet. In a suit filed by the former employee, the employer argued that it had consent because the employee did not delete her password prior to turning over the phone. And the court held that Verizon and its employee did not have authorization to search the terminated employee's personal emails simply because it had a policy that stated it could monitor all email and internet use. They also opined that Verizon could potentially be held liable under SCA for the action of its employee opening emails that the former employee had not yet opened. So, if they have evidence that emails were sent to Jen that she didn't open and Stephanie opened them first, that could be a problem. And maybe they do have that evidence. Maybe that's why they're bringing this claim. Right now, we don't have all of the evidence that they have for their claims. The wiretapping might be harder and the storage might be harder when it comes to text messages. And that's, going to be up to a judge to decide from a legal standpoint is can that survive a motion to dismiss? But the other issue as it relates to the wiretapping as well as to the California Penal Code is that this is the second district of the appeals court, which includes the Southern District of New York, and that is not California or the Northern District of California. That's in a completely different appeals court. And so often the first line of defense for these motions you'd want to be using arguments from the district that you're in. And she's citing cases from Northern California that aren't even related to Southern California, where this would have been if it were a California case. And she's not applying any second district, or the second circuit, which is where they're located. So I think it's going to be hard for them to throw this out based on the fact that a lot of what they're arguing about is statements of fact. And I don't think a judge is going to want to throw this out at this stage because it's an appealable decision. And so if he throws it out, they can appeal it. And if the court goes back and rules and says you shouldn't have dismissed this, then the judge can get in trouble. So they don't like to throw cases out on motions to dismiss for that reason. I don't want to go into the whole document because honestly, it would take 30 years and we're already at, 35 minutes here. But there's one aspect of this that none of her arguments are going to or they're intentionally avoiding. And that's that Jen says that Stephanie didn't have a written policy in her workplace that she would have the ability to monitor emails. Stephanie didn't implement a workplace policy on storage of data, and there wasn't any consent from an employer to employee policy that says, I'm going to be able to monitor your emails. I'm going to be able to monitor your text messages. You don't have an expectation of privacy. And there's been recent cases in district courts and appeals courts. This comes from an article from Business Law Journal, and it says that a recent decision by the California Court of Appeals found that something more is required. Without a clear policy in place prohibiting the use of an employer's email accounts for personal purposes and informing employees that their work email accounts are subject to review, an employer may be prohibited from doing so, and evidence collected in that matter may be inadmissible if a dispute arises. And that's just related to the work emails. That's not just related to the personal emails. And one of her arguments is that Stephanie did not have a policy in place that prohibited her from using this for personal reasons. And that is something that the motion to dismiss is intentionally ignoring. And here's one of the bigger issues is that this is a civil case, not a criminal case. All of these are criminal statutes that have a civil component. And the circuits in the United States of the appeals courts are very divided on how they define what an employer can and cannot do. So the Second Circuit, which is where they're located, it says that They have a right to monitor employee emails used on company provided devices, even if personal emails accessed on those devices, as long as they have valid business reason and a written policy in place. However, the extent to which they can access personal emails and the level of employee privacy they are allowed to infringe upon is a complex issue. Because the circuits of the appeals courts are so divided on how and what employees are given a right to for privacy, it there is privacy for employees. So the flat argument that employees have no expectation of privacy is not legally sound. But because it's such a split decision, I think what's gonna happen is you're gonna see a bunch of different arguments from Wayfair that and Jen Able that they didn't have a policy in place, and that's what matters. Because in order to have a policy in place, that would imply that the individual is consenting to that policy, and that would include that by handing this over or by working for you, if I put personal information on the phone, you're going to monitor it. And if she had known that Stephanie was going to monitor her texts and her emails for personal use, she may have chosen or opted to use her own phone. But because there was no agreement and there was no policy, it's going to be hard for Stephanie now, after this is all said and done, to say that she had an authorized business related purpose when she never had a policy in place that anyone consented to that she could monitor her emails. Stephanie didn't do the work on the front end. And I think that's what Jen's side is going to rely on. Will it go through a motion to dismiss? I think so. I think she'll survive. Like, I think Jen's case will survive. But more importantly, if I could just tell these lawyers anything, and this is just coming from a mom of a 12-year-old boy that's disabled, that we should reconsider using language in our motions and in our filings, taking aim at and degrading people. We can make really good arguments without being mean. And by what I mean as being mean is using insults, but also using text messages to try to paint a narrative of someone that's not true, and to cherry pick text messages to create a narrative for the public relations. I'm getting really tired of reading these motions to dismiss and reading these motions of how just belligerent and angry these people are towards one another. And if these people were my lawyers, I would fire them for this kind of behavior. You would expect a lawyer to have decorum and to be ethical and to not go below the belt and to be above board, to follow the rules of candor and to be ethical. And in this case, you have Kristen Taylor trying to defend the fact that Stephanie Jones handed over evidence through an illegal lawsuit, through a sham subpoena, and trying to deflect that, turning Jen Able into the scapegoat. And it further is asinine for anyone to believe that Stephanie Jones, the owner of Jones Works, who knew that Nathan had been hired, who was privy to all of the details of this alleged smear campaign, and who herself tried to insert herself into this case and into the PR and talked to the Daily Mail and shared information and called it a nothing burger, is now suddenly calling it a smear campaign for sexual harassment. But as long as she could have had Wayfair as her client, she still would have been there with them today. The only reason she's doing this and saying it's this way now is because of the guilt that she has. Because she has not provided any evidence that Jen Able spoke to anyone, that Jen Able planted any stories, that Jen Able implemented any strategy, or that Jen Able said a word that was disparaging about Blake Lively. She has private text messages of things that were said in between people that worked, but there's text threads where she's on them along with workers of Jones Works that were involved in this. Jen wasn't the only person on this account. And to go after only one and not everyone else, that's the suspect part for me. It's just petty, it's childish. And personally, all of this just makes me never, if I were a celebrity, I would never hire Stephanie Jones, because what Stephanie Jones will do is if you're her client, she's going to charge you an exorbitant amount of money for crappy PR. And then she's going to use her position as the PR agent to gain confidential information about you that she's then going to weaponize against you when things fall out. And that's retaliatory. Your duty as a PR agent is to protect the confidentiality of the information that you have and not to ruin the person that fired you because you're mad. It says a lot more about her than it says about Justin or Jen because they didn't say anything about Stephanie until now, until she made this entire mess happen, until she and Lively conspired to create this fantastical nonsense story. And Kristen Taylor and all of these attorneys that are now under the threat of possible sanctions, uh, having their being reported to the bar, are now trying to flip all of this on Jen Abel and accuse her of doing this when they're the ones that did it. It's just so deflection. I can't stand it. I hate these kinds of litigants. I would never hire Kristen Taylor. I would never hire any of the attorneys that are representing Lively. They're opportunistic. They're pushing a false story and they're billing her up the ass for all of this. It's all just a continued smear campaign. So, what are your thoughts about this? Let me know what your thoughts are in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.